If you can no longer have sex as a result of the injuries you suffered because of a doctor's carelessness, how do we actually prove that during the course of your lawsuit? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. You know, that's a question that comes up from time to time. I have somebody, an injured patient, who comes into my office who tells me, listen, as part of the injuries I suffered, my spouse and I no longer have the ability to engage in sexual intercourse. And the question for them is, how do we actually prove that? Well, we do that a number of ways. We do that through your medical records. Now, during the course of time that you're recuperating and under the care of a doctor, you will have told him or her about the specific complaints and the problems that you are having. You will likely also tell them about the things that you can no longer do. I know that some patients don't even like to talk about this topic, even with their doctors. But the reality is, that's one of the key ways that we are able to show that we are more likely right than wrong, that what you are claiming is actually true. Because think about this. When you bring a lawsuit against a doctor claiming that he violated the basic standards of medical care, now we have to obtain all of your medical records to confirm that there were violations from the basic standards of medical care and that those violations were a cause of your particular injuries. So now, when you actually bring a lawsuit against the doctor or hospital who you believe caused you harm, their attorneys will do the same investigation that we do just many months later. And now, one of the things that they're going to do is look at the medical records. What complaints did you have? What problems did you have? What did you tell the doctor? What did the doctor's examination show? Is there a physical reason why you're no longer to engage in sexual relations with your spouse? Based upon the medical records, they will now form an opinion or a conclusion in their own minds as to whether or not you are able to engage in sexual activity. And in addition, during the course of your lawsuit, they'll have an opportunity to question you, the injured patient, about what you can and can no longer do. And during that question and answer session, which, by the way, is known as a deposition, the defense attorneys will have the opportunity to ask you questions about those activities you could do before and those activities you can't do now or have difficulty doing. And together with that information, that's how we show that you are unable to have sexual relations with your spouse. Otherwise, they don't put a hidden camera inside your bedroom in order to see whether you do or don't have sexual relations. It doesn't happen that way. Instead, they rely on your testimony and they rely on the doctor's information in their records to determine and formulate a conclusion about whether or not what you're claiming is in fact true. So why do I share this great information with you? You know, I share it with you to give you an insight and an understanding into what goes on in a medical malpractice case here in the state of New York. You know, I realize you've got questions or concerns about your own particular matter. Well, if you're contemplating bringing a lawsuit because of a doctor's carelessness and you've got questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.